Thank you for joining us today for today's event, Disability 101 for Libraries, presented by Kelly McCullough, Director of Legal Services from Disability Law Colorado. This event is being hosted by the Colorado State Library. My name is Christy Moran. My pronouns are she, ella, and I am the Adult Library Services Senior Consultant, or as I say, a librarian for librarians and library staff in Colorado. Today's event will be recorded. Sorry, I'm letting people in. And all registrants will receive an email with a link to the recording. Additionally, at the end of this presentation and in that follow-up email, I'll be sharing a link to the survey. Our presenter has just let me know that she will also be sending us her slides, so I'll be able to send that in that follow-up email as well. The State Library uses this survey, the one I'm going to share, to inform our work and to report on the value of our programming to you. So now I'm going to turn it over to our presenter, Kelly McCullough.
Hi, thank you guys so much. This is an amazing attendance. I'm really excited. I did a presentation on Tuesday that had 7 people, so this is really exciting. A little bit nerve-wracking too, but I'm gonna go ahead and share my PowerPoint. And feel free to put questions in the chat as we go. And I will definitely make sure I save some time for questions at the end. So as Christy stated, I'm Kelly McCullough, Director of Legal Services with Disability Law Colorado. We're doing Disability 101 for libraries. And so first just, oh, I should actually start the slideshow, sorry. There we go. And so just a little agenda. So an overview of what we do as an organization, an overview of the ADA and disability as defined by the ADA, a little bit of an overview into Title II public entities, which is what would primarily be covering libraries in the ADA. And a little bit on disability etiquette tips, and then some other issues that people with disabilities face that I think you probably see in your patrons in housing and transportation, just kind of a little surface level about those issues. So we are Colorado's designated protection and advocacy system. Every state in the US and every territory as well has to have a designated protection and advocacy system. So I think there's 57. DLC was designated in 1977. We work to protect and promote the rights of individuals with disabilities through legal representation, advocacy, monitoring, investigation, education, and legislative action. So we do some direct representation. We do tend to focus on direct representation that can affect people systemically. We're a relatively small organization that has to work to help people with all disabilities all across the state of Colorado. And so taking on every case that comes through the door is just not possible for us. But we also have developed a lot of self-advocacy materials. So handouts and guidebooks and things that people can use to advocate for themselves as well. We do go into places that serve people with disabilities and monitor for rights violations, abuse, neglect, those things. If we do get reports of abuse and neglect that resulted in serious bodily injury or death, or we're likely to result in serious bodily injury or death, then we do investigation into that. We do education like this presentation here. And we also work on educating lawmakers about disability issues around bills that they're considering. So areas that we focus on in our work, this isn't, exhaustive, but this is kind of an overview of what most of our work is around, is housing, employment, public accommodations. We're really focusing in right now on transportation, and especially public transportation. Facilities like jails, prisons, group homes, regional centers, hospitals, nursing homes, education. So students with IEPs and whether their needs are being met. And we're especially looking at education in facilities. So the state still has the right to obligate people, or the state is still obligated to provide education for people who are eligible in youth detention facilities and places like that. And as you can imagine, a lot of those people have disabilities. We handle Department of Vocational Rehabilitation complaints. We also do representative payee investigations. So when somebody has a disability where they've determined that the person can't be responsible for their money, then they may be assigned a representative payee. And sometimes those people abuse that obligation that they have and use the money for things that they're not supposed to. So we do investigations into that. And like I said earlier, we're focused on systemic impact work, but when people do contact us, we do try to provide those self-advocacy resources. Also very exciting that we're hoping to come out within the next year is some videos to help people who reading might not be their best way of obtaining information, some videos to help people with self-advocacy as well. So Section 504 of the Rehabilitation Act is the precursor to the ADA. It was really the first time the US really codified recognizing a right to be free from discrimination for people with disabilities. And then the ADA expanded from there. And so in 1990, that was passed. And the ADA has 5 titles. The Title I addresses employment, Title II, state and local government and public transportation. So that's where libraries would typically fall. Public accommodations is private areas, telecommunication relay services, and other miscellaneous provisions. So the definition of a disability under the ADA. So there's 3 prongs that establish whether or not somebody is protected from discrimination under the ADA for a disability. First is the most common, and it's an individual who has a substantial impairment to a major life activity. So you're looking at, is there an impairment? Is it to a major life activity? And is the limitation substantial? In 2009, there was an amendment to the ADA that significantly changed how this was interpreted. And so since then, the courts have interpreted this pretty broadly. It's not supposed to be a really hard bar to meet. But to walk you through an example, let's talk about somebody who has post-traumatic stress disorder. So somebody who has post-traumatic stress disorder, PTSD, they experience substantial anxiety and maybe panic attacks that can make it hard for them to go in public or do their work, and may make them want to isolate and stay at home more. And those would be all things that would be an impairment to a major life activity: going out, socializing, working, living your life. So under the ADA, the mitigating factors. So this is a little bit complicated. It's kind of like a double negative. So let's say somebody has had an amputation and they use a prosthetic limb. With the prosthetic limb, they walk and run and everything just as well as anybody else. But without the prosthetic limb, obviously they wouldn't be able to walk and move around as much. Obviously, I'm talking about a leg if I'm talking about walking around. So without the prosthetic leg, they wouldn't be able to walk around. And so that is still a disability, even though that if they have a prosthetic that helps mitigate the effect on their life, because without the prosthetic, they still would have a substantial impairment to a major life activity. The one exception for that is eyeglasses and contacts. So the ADA does not consider you to have a disability if you need eyeglasses and contacts to see like another person. If I didn't have my glasses, I would definitely not be able to drive. Walking around would be dangerous and difficult, but that the ADA does not consider that to be a disability because normal eyeglasses or contact lenses correct that. So major life activities, caring for yourself, walking, seeing, breathing, learning, performing manual tasks, hearing, speaking, or working. So those would be, this is not an all-inclusive list. You could think of some other things as well that would be major life activities. Is there a substantial limitation to them? So that's a question of degree, right? So if somebody has something that's impacts them just very, very minor in that area, then that would not be considered a disability. But if it's a substantial limitation, it is. So prong 2. So this is one of the less common and less known disabilities. So, or definitions for a disability. So it's an individual who has a record of a physical or mental condition that limits a major life activity. So somebody who previously had something that met prong 1, or may not have met prong 1, but kind of would follow along those lines. I'll explain in a minute that differentiation, but like a clear example is cancer. So if somebody has had cancer and the cancer is now fully in remission, it is still something that is recognized as a disability for some of the purposes of the ADA. It's not recognized as fully as prong 1 for certain things. So if an employer is like, oh, I found out that you used to have cancer and I'm worried that that's going to come back and would impact, our health insurance prices or us having you work for us and having somebody consistent in this position. So therefore I'm terminating you. That would be discrimination that would be protected by the ADA. You could not do that. And additionally, if you needed a reasonable accommodation for your doctor recommends that you come in once a year to have a cancer screening or to have some treatment every so often, and you need to have your schedule accommodated at work for that, it would allow for that. However, a lot of the accommodations would be much less for something that is no longer affecting a person's major life activity. And so history of past drug use is a more complicated one. If somebody has had a drug addiction in the past and has not that you defeat it, you still have the addiction, but if they are no longer actively using, that is something that can be considered a disability for protection. Once again, you could see an employer saying, well, you used to be using drugs actively, and so we're no longer going to have you work here because we're afraid you could relapse and that could cause us some problems. That is not permitted. That would be discrimination. However, if you are actively using, that is not considered a disability, and that is not protected. So if somebody's actively using, maybe they're trying to stop and want to go to a rehab or something like that, and they want time off work to do that, that's not actually something that an employer has to do, because it's an act of drug use, and the ADA does not recognize that as a disability. So prong 3 is kind of the least common. So it's an individual who's regarded as having such an impairment, whether they have one or not. So an example would be a port wine stain or some scarring that you have that doesn't impact your life at this time. Those are your major life activities at this time. Those are things that they aren't a substantial impairment, but the ADA recognizes it and protects it to the extent that somebody's discriminating because they they assume you have that impairment. So they believe that because of that scarring that you have a disability, and they're discriminating against you because of that. And the ADA protects you against that. A person who is regarded as having an impairment without actually having an impairment that impacts their life activities, they can't ask for a reasonable accommodation. So they can't say, you assume I have a disability, so now I'm going to ask you to accommodate a disability I don't really have, or an impairment I don't really have. Okay, so then Title II. So this is what would cover libraries, would be the primary thing that would cover libraries. I keep saying that because there's certain things about websites and other titles that would also potentially impact publicly funded libraries. So the ADA applies regardless of the size of the public entity. So whether or not it's a library that hires, 2 librarians or 200 librarians, Title II applies. It requires that individuals with disability have an equal opportunity to benefit from programs, services, and activities of the state and local government. So an equal opportunity to benefit is really what you're looking for. So if there's a program that exists that somebody is, because of their disability, not getting access to for one reason or another, how can you enable that person to have an equal opportunity to benefit? What does the ADA require of public entities? So specific standards when constructing a new building or altering an existing building. So there's standards that exist under the ADA. Some buildings are older than the ADA and the building standards. And so if that's the case, they may be able to, continue to operate in that building, but to the extent that you can, you still have to try to make sure that that person has the access to the programs and services that are offered. So relocation or alternate access to programs in older buildings that are not accessible, effective communication with individuals who have hearing, vision, or speech disabilities, documented self-evaluation to ensure complying with the ADA. So ADA, this is something that's different for a public entity than a private entity. So a lot of these things would apply to private entities too, but the documented self-evaluation that you have to set, like every year, we are going to evaluate our policies and procedures in our building to make sure that we're complying with the ADA. Reasonable accommodations to policies, procedures, and practices. There's an exception that you don't have to take a requested action for a reasonable accommodation if it's a fundamental alteration or an undue burden. And then a public entity with more than 50 employees has to have an appointed ADA coordinator who coordinates the compliance of the ADA and serves as a point of contact to people with disabilities so that that person can contact the ADA coordinator to request auxiliary services and other things, other reasonable accommodations. That entity must make the contact information for that coordinator accessible, so make it public, and must also have an established grievance procedure that they post where the public can see it. Architectural access. So architectural barriers are physical elements of a facility that impede the access by people with disabilities. So it can be steps that lead to the doorway of the business, doorways that are too small for a wheelchair to go through, tree branches that hang too low over a sidewalk. There's many others. If a public entity is unable to provide access by removing the barriers, it's required to provide alternatives. So portable ramps, an alternate entry, home delivery of goods, or meeting at a different location. So for instance, if you had a library that's in a very old building that has a lot of steps up, and because of the location of the steps, putting a ramp is not possible, and there's a person with a wheelchair who wants to come to a meeting that is offered by the library, then you might have to say, well, we're not going to have it at the library, we'll have it at City Hall or something like that. Service animals. So service animals, fun fact, it's either a dog or a miniature horse. People don't know typically about the miniature horse being a service animal. Has to be individually trained to provide assistance to the individual with a disability. So there's a lot of confusion right now because people have emotional support animals and people have service animals. Those are two different categories. An emotional support animal is an animal, it could be any animal. They haven't been specifically individually trained to provide assistance with a task that's affecting the person with a disability. They just offer that person emotional support, or there's things like if you have major depressive disorder, it's very hard for you to get up out of bed in the morning. But having a dog who needs to be walked first thing in the morning helps you get up, get out of bed, do the things that you need to do, walk the dog, and get your day started. That could be something that would be an emotional support animal. The dog needing to go outside and go to the bathroom and be on a walk, that is not something they're trained to do. It's just something that's inherent in their existence. So that's an emotional support animal. For a service animal, that's a dog dog or miniature horse has been trained for a very specific task to provide assistance to that person with a disability. The go-to for most people, like the thing that most people think of, is a seeing eye dog, a dog that helps to guide somebody with a visual impairment around. That is definitely an example of a service animal, but there's so many different things that dogs have been and horses have been trained to do to assist a person with a disability that it's kind of endless these days what we've figured out can help. Dogs that are trained to, by smell, detect whether somebody's insulin is getting low and they're likely to have a problem if they have diabetes. A dog that is trained to sense when a seizure is coming and alert their owner to sit down, so that they don't fall. So very many different things that they can be trained to do. There is no requirement for licensing, certifications, or a vest. So asking somebody if this is certified or licensed, that's actually meaningless under the law. There's rackets online that people pay for to get their animal certified, but that they don't actually do anything to make sure that they actually are a service animal, and it's also not required, so it doesn't really mean anything legally. The only thing that a public entity can ask if somebody's brought a service animal in is that animal required because of your disability, and what task does it perform? You cannot ask what the disability is or documentation like a doctor's letter or something like that. And most people know this, but if you do see a service animal, even if they're really cute and seem really sweet, don't pet them. They're working. They need to be helping that person and focusing on their job. So disability etiquette tips. People first language. So people first language is something that I have a question mark next to, because it's not always what the individual prefers. It was definitely something that has been promoted as using, and so people first language is saying a person with a disability rather than saying a disabled person. A disabled person is identity first language. And so people first language was definitely promoted as the preferred option. However, that changes by person, and that changes also, so there are things like within certain disability communities that there's certain disability communities that definitely tend to prefer person first or identity first language, but that doesn't mean that a person in that community doesn't feel differently. So for example, within the autism community, a lot of people prefer identity first language. So they prefer being referred to as I am an autistic person, I'm an autistic man, whatever. Whereas other people might prefer people first language, but even within the autism community, that varies. So there's no assuming. So people often will ask me, well, what do I do? How do I refer to people? And I would say that, first of all, do you need to refer to the disability at all? So that's the first question to ask. If you don't need to refer to the disability at all, then you don't need to worry about it. Don't say anything about it. If there is a reason why you would need to refer to the disability, what has that, sorry, I have a delivery person. I don't know if you can hear my dog barking. Sorry about that, but so whether or not you need to refer to it at all, if you do need to refer to it, what has that person, that individual with a disability, used previously? So have they said that they if they have autism, have they said I have autism, or I am autistic? Because that usually is a sign of, I am autistic is usually identity language. I have autism is usually person first. And so, and how, have they referred to themselves in person first or identity first? And then you typically want to mirror the language. You can also ask that person, how would you prefer I refer to you? Once again, not unless you need to. If you don't need to, then you don't need to. And so lastly, when you're referring to people with disabilities generally, when you're giving a training on disabilities, like I am right now, I defer to person first language. So I think that is usually the accepted kind of baseline, is to do the person first. And then when you know that somebody prefers identity first, when referring to them, to use that. Okay, so the second one, pretty obvious, but don't patronize. Also, don't make assumptions. So some people assume that if somebody has a stutter or speak slowly, they might, or maybe they have cerebral palsy that causes certain speech patterns. People often will assume that means that that person has an intellectual disability and talk to them different. Don't talk to anybody different until you realize, like, maybe this person, based on the conversation and how they're not understanding, that maybe you need to talk a little slower or whatever. And always feel free to ask, like, is there something that you would prefer for me to use when explaining? Like, is writing something down as I talk helpful, or something like that? Be patient. Don't pet, feed, or distract service animals. They're working. Don't touch a mobility device without permission. So never, ever touch somebody's wheelchair unless they've given you permission. It's that's their legs. So would you touch their legs? No. Speak directly to the person, not the interpreter. So if you have like a American Sign Language interpreter who's working with the person, be looking at the person and talking to the person and not addressing the interpreter. Relax and be yourself. Don't worry about common phrases like "see you later" to somebody who's visually impaired. And I think the baseline rule is to just come back to, what would how would you want to be treated? How would you treat anybody else? And then if somebody asks you for, a reasonable accommodation to be treated differently, to work with them and provide that. What are some other laws that protects people with disabilities? So this is not comprehensive. There's more out there, but generally, the Fair Housing Act protects people in housing with disabilities. Individuals with disabilities in Education Act, the IDEA, protects people in education settings. Section 504 protects people from anyone who is receiving federal funding as a substantial contributor to their existence. Protection of Persons from Restraint Act. So this, it has to do with restraining people with disabilities. The Colorado Anti-Discrimination Act. So a lot of people don't know this, but Colorado has codified a lot of what's in the ADA and even expanded beyond it. So there's some areas where CADA actually offers more protection. And by the way, you'll hear people say CADA or CADA. I typically say CADA, but it does kind of go either way. But the Colorado Anti-Discrimination Act has some things like the ADA doesn't recognize service animals in training as a service animal, but CADA does. So if somebody's bringing in a puppy that is in the process of being trained to become a service animal, that is a protected animal, even if they haven't yet been individually trained to perform the task in Colorado. The Air Carrier Access Act, that has to do with disability access in air travel. So that's just a sampling of some of the other laws that protect people with disabilities. Discrimination in housing. So I was just trying to think about in libraries where you might see people who could benefit from having information in other areas. And housing, of course, we know we're having a housing crisis here in Colorado, like a lot of the country is. And so housing issues, we're seeing an increase in them. We're seeing long settled issues where landlords are feeling empowered to not have to do the things that they previously recognized they had to do. And so I was thinking that that might be something that you are seeing as people dealing with discrimination in housing. So fair housing laws, the Fair Housing Act, the Fair Housing Amended Act, which added protections for people with disabilities, CADA, the Rehabilitation Act, Section 504, Americans with Disabilities Act, and local laws and ordinances. So reasonable accommodations. So reasonable accommodations in housing is a change, exception, or adjustment to a rule, policy, or practice or service that may be necessary for a person with a disability to have equal opportunity to use and enjoy a dwelling, including public and common use spaces. You cannot charge a housing provider cannot charge a person for a reasonable accommodation. Examples would be creating an exception to a first come first served parking policy. This is actually something we see a lot. So somebody has a mobility disability. There's a big apartment that has a big parking lot that, you know, you get there at a certain time of day and you're having to walk a football field, or if you get there at the right time of day, you're right next to your apartment. So creating an exception to that first come first serve rule and assigning somebody a parking spot, or even repainting the parking spot to give somebody an assigned spot that's close to their apartment that is wheelchair accessible to a wheelchair van, something like that. Those are all things that would be reasonable accommodations. Allowing a tenant to pay rent by mail rather than having to walk it in or having to do online or something like that if their disability prevents them. Another thing is adjusting the date that rent is due. So if somebody receives SSDI or SSI and their check comes at a different time of the month, and so paying it at a different, you know, the landlord wants it by the 30th and their check comes on the 15th, changing the date of the deadline is a reasonable accommodation. Allowing assistance animals in no pets buildings. And in housing, emotional support animals are treated exactly the same as service animals. So in libraries, emotional support animals would not be recognized as being protected, but in a housing setting, an emotional support animal treated exactly the same as a service animal. Reasonable modifications are a structural change made to existing premises occupied or to be occupied by a person with a disability in order to afford that person full enjoyment of the premises. The tenant is responsible for the cost of the modification unless the property is government owned. So if it's a housing authority apartment, then the housing authority has to pay. Examples are widening doorways, installing grab bars, lowering a kitchen sink, and adding a ramp. What a private landlord has to do, or a private rental manager has to do, is allow that person to make those changes. So they have to allow reasonable modifications so long as they're done by a professional. They do not have to allow an amateur to take down a wall and do something else. They do need to be professionally done, but they have to allow that. And there are some organizations, Brothers Redevelopment is one on the Front Range, that assists people with getting those reasonable modifications. Discrimination in renting. You cannot refuse to rent to somebody because of a disability. That includes refusing to rent because they need a reasonable accommodation, like a service animal or assigned parking. You cannot discriminate because they need reasonable modifications. So you're going, I don't want you to be changing my building, and the landlord is trying to say that you can't move in because you have to change, he would have to let you change the building. Can't do that. If requested, they need to make reasonable accommodations in the renting process. So somebody isn't able to fill out their application, they need to work on a different way to accommodate that application. There's new housing laws that have been passing in the past few years that many people don't know about that might help people who come to libraries, who might be bringing up these things. A landlord cannot consider a rental or credit history more than 7 years old, and a landlord can't consider criminal history convictions more than 5 years old. To the criminal history convictions, there are some exceptions: manufacturing methamphetamine, some sex crimes, and some serious crimes of violence are exceptions. But overall, most convictions, they cannot consider if they're more than 5 years old. So saying we don't let people come in with this type of charge is no longer allowed, or any type of charge, not allowed. Bans, another law bans discrimination in housing based on source of income. This is, I'm throwing this in because I feel like this law is something that could help so many people, and we go places and so many people have never heard about this law. And I think it could make a huge difference if people knew, because landlords don't know even, or if they do know, they're ignoring it, and people don't know they have this right. So if your source of income is SSI or SSDI, or you have a housing voucher, they're no longer allowed to say, we're not accepting you because we don't take that source of income. In eviction proceed, and this is a new law that hopefully is getting signed this afternoon by Governor Polis. In an eviction proceeding against somebody who receives SSI, SSDI, or Colorado Works Assistance, there must first be mandatory mediation before the eviction can proceed. So this is helping to protect the people who are most vulnerable, most likely not going to be able to find a new place, to try to stop evictions from happening to those individuals. Discrimination in transportation. So just a little rundown on this, because I'm assuming a lot of people who come to the libraries might be coming on public transportation. In transportation, the ADA explicitly protects people from disabilities in public transportation. In the public accommodations, it would also protect people in private transportation. There's other laws that state specific obligations that public transportation and private transportation providers have to do to serve people with disabilities. And people who are experiencing discrimination can file complaints with FTA, Federal Transit Authority, and Colorado Civil Rights Division. And people who are experiencing discrimination in housing can also file complaints with Colorado Civil Rights Division. So that's just a little overview of two issues that I thought might be issues that libraries might see. If you're going to refer anyone to us, they should go through our intake process by contacting us in one of the following ways: either calling us or submitting an intake packet on our website. We have a fillable PDF with intake packet. And that's all. There's my email. I will be providing these slides. And I wanted to save some time for questions. Where are we on time? Oh, let me just do a real quick, effective communication is also an issue that we see a lot come up in different public entities. So effective communication is when somebody has a communication disability, if they're visually impaired, hearing impaired, or have some other issue that affects their communication, they can ask for accommodations in effective communication. So obvious things is asking for a sign language interpreter or something like that, but they can ask for other things as well. Some handouts to be provided in Braille, or Braille is much less commonly used these days with all our advances in technology. A lot of times recording, doing an audio recording of something that was provided in writing is the preferred method. So somebody can ask for those as a reasonable accommodation. With effective communication, the standard is that the communication must be as effective as it would have been for somebody who doesn't have the communication disability. So whatever method you use has to be as effective as talking would have been, if it's a talking situation, as talking would have been to a person without a disability. And so what the law looks at in those circumstances is they look at the depth of the communication. So for instance, if somebody comes to a library desk and says that they are looking for, are asking about a book, and they're deaf, and they pass you a note asking about the location of a book, in that circumstances, probably passing them a note back that says where that book is probably going to be equally effective. However, if somebody comes up and they are looking for, something in a category for a research project that's complicated and is going to take more than that, potentially if they're asking you to contact like a translation service to have a ASL interpreter help with this situation, that is something you would have to provide for the more lengthy, more complicated communication that's occurring. And these days with technology, it is so easy to get somebody on the line right away. Language Line is available right away. You don't have to set up an appointment. I've used them for ASL interpreters and had good results. And so just keeping that in mind for effective communication. Okay, and now I'll open it up for questions. Sorry.
I believe Jana wants to go ahead and clarify her question. So go ahead, Jana. I believe you can access your mic.
Okay, hi, sorry. Okay, thank you. Yeah, this is something as a librarian that works at a public reference desk that has occurred for me, where folks will come up and they will just speak to me, and I do struggle to understand. And like I said, it's not an accent, but it's a speech impediment of some sort. And I have just wondered, like, we do have access to the Language Line. We could get sign language interpreters sometimes on staff as well. But if the person just comes up to me and is speaking, would I want to wait for them to ask for the interpreter or something like that? Or is it okay to say, I'm having difficulty understanding you, can we write a message? I just want to know what is the most friendly approach, because I do have access to different things. And I also wonder, is it kind of on them to determine, hey, I will ask for this if I want it, but I haven't ever had one of them say, I would like a sign language interpreter, or do you speak sign language?
Yeah, I think that's a great question. So first, in terms of legal obligation, which is a floor, right? The legal obligation is a floor, and we always want people to do more. So we'll address the floor first, though. If somebody is asking for a reasonable accommodation, that's when it triggers a legal obligation. If somebody has not asked for a reasonable accommodation, then there is no obligation to offer it or provide it. So legally, you're in the clear to not do anything further at that point. However, as your question sounds like, is that you would like to try to figure out if there's a better way to provide them the information and make sure you're understanding the question and they're understanding your answer. And I think that's always a good place to come from. And so I think that's great. So at the next level, I would say that, you don't want to assume. So you want to kind of let that person do the back and forth a little bit and see if they understand, if they haven't been asking. But if they do have a question, or if in that process you're still not really grasping what they're asking, I think that the best way to go forward from there is to say, I'm having some trouble understanding your question. Is there something that I could do, a service I could use, an accommodation I could make that would help? And if you feel like that person might understand that better, if you write it down, I'm not sure, if you're concerned they're hearing or whatever it is, I think that's okay as well. You don't ever want to kind of presume what accommodation that they're going to need is. So, you might offer ASL, but that might not be at all what they are needing. So they might have another idea. So I'd keep it open when you offer to consider some other alternatives, and just, say, I'd like to make sure that I'm understanding you fully. And I'd keep it on your understanding and not assuming they're not understanding you. So keep the focus on you and you understanding their questions so you can fully address it. Okay, great. And I do want to make one, because I said that you don't have to make a reasonable accommodation unless somebody asks for it. And that is true. An exception would be if if some situation is extremely clear, that any reasonable person would understand that this person has a disability and there is an accommodation needed. Like, for instance, somebody who's visually impaired, who's coming in with a seeing eye dog, that assume being like, okay, that is a reasonable accommodation, we're making it. Like I said, asking that person, what's your disability, at that point is not appropriate.
We have another question in the chat, and I want to read it so that it can
Great.
be captured in YouTube captions. If I post a job and have an applicant who is on an income restriction and can only work a certain amount of hours per week to stay under that income limit, but it is not the amount of hours the job is posted for, am I able to decline them for a position, or would this be a form of discrimination? And we've been offered an example. So for example, the job is posted for 24 hours per week, but they tell me they can't work more than 20 hours per week to stay within their income restriction so they can live in the apartment building they currently live in.
So because I cannot provide legal advice because I'm not representing you, I'm not going to address the exact question, but I'm going to kind of broadly talk a little bit more about the law. So in employment law, which could have been its own, it can be its own all day session, it can be its own all week session, but with employment law, somebody is entitled to reasonable accommodations that would allow that person to effectively perform their essential functions. And a person is a protected person for employment so long as they are an individual that, with or without those accommodations, could perform the essential functions of the job. So if the essential functions of the job are to work 24 hours a week, and that's an essential function, there's very specific reasons why that person has to work 24 hours a week, then if the accommodation they're asking for is to not perform the essential function of working 24 hours a week, then that is something that is not protected. And so I can't directly answer the question, but if it is something, and case law gets into all sorts of debates about whether something truly is an essential function or not. But we also do have on our resources on the website that Christy put in the chat, we do have an employment packet that you can review as well.
Excellent. Someone had asked a question. I also asked a question. So while I wait whether or not that question was answered, in the library, we do a lot of programming, right? For, like book clubs, or maybe have an event or a speaker come, or a crafting session. And we use a lot of language for promoting those programs and events, and also in our policy documents. So I had asked, it's a question that comes to me often, is what is the best language to use in those cases in order for us to be inclusive of physical and intellectual disabilities and or other communication disabilities, things like that. So how could we, what kind of is the best language that we could use in cases like that?
And this is about person first versus identity first. Okay, yeah. So I defer, and I think the safest route for most people is to defer to, when you're speaking generally, defer to person first language. I think that more people prefer person first. I haven't done the studies, but it seems to me that more people with disabilities prefer person first language generally. So I would defer to that when doing it generally. I think that will save you the least problems. It doesn't mean that there won't be somebody who's offended, but most people, even if they individually prefer identity first language, they usually know plenty of people who prefer person first language and will be okay with that.
All right, I invite anyone else to enter questions in the chat, or I have other questions. I always have questions about inclusive behaviors in libraries. As I was just speaking with someone who does programming at a library, at a public library in Colorado, and she had a question regarding the best use of, or best ways to ensure that programs are accessible when we're holding them. For example, she had heard, and I also had heard, that all programs and events, we should be using microphones and speakers. Like, are there other things like that? Or have you heard that that's true? Or is that a best practice you think that we could employ?
I mean,
Similar
I think that can be. I think there's also, if you are worried about people who, so my previous job was as a public defender. And so courthouses have, many of them have like headsets that act like a lot like hearing aids for people who have hearing impairments. So that can be helpful. Having a simultaneous video with closed captioning can always be helpful. I will tell you that the deaf clients that I have almost exclusively prefer Google Meets. So if you're trying to pick the best meeting platform, online meeting platform to use, Google Meet seems to have the best real-time closed captioning available. Trying to think of some other things. I mean, I think always when you advertise it saying we will provide reasonable accommodations, I mean, people know that, and that is the law, but some people don't. Some people get a disability late in life, and they may not even be identifying as somebody with a disability because it happened later in life, and they're just like, well, hearing loss is what happened. And so, but letting people know that you'll accommodate disabilities, and you can enumerate like some things as well and say it's not as all inclusive.
So Renee would like to ask a question. I believe you can chime in and unmute.
Yes, can you hear me?
Yes.
Okay. My question is, in our library, we have an astounding amount of public computers, over 70. And we have some patrons who regularly come in who have visual disabilities that are so severe, they're using magnifying glasses. How quickly do we need to provide an accommodation, Kelly? Do you think that we should necessarily have on hand at least like the physical monitor magnification tools that we can put on? Or maybe one or two computers with the software loaded? How quickly do we have to do that? Because they're there right now.
So once again, the legal floor is if they've asked for it. So if they've
Okay.
asked for it, then you need to provide it. If they haven't asked for it, you don't need to provide it. However, I do think, you know, if you want to make a place as welcoming and you do see people struggling with that, you know, having that stuff available is great. Having screen reader software available is really great, and having headphones so that person can use the screen reader and not have to bring their own headphones. That would also be something that's helpful for people with visual disabilities with using computers.
Thank you. Our director is very proactive. I would expect that she would want us, if we see it, if it's severe, to be able to offer something on the spot, if we could have something that's not financially burdensome.
That's great. That is great to hear about your director.
She's on this call. Hi,
Oh.
Jess.
That is great. So I am putting a resource in the chat too that so this is askjan.org. It is the Job Accommodation Network. So it's targeted towards accommodations in employment. However, I think it is extremely useful for accommodations for everything, because you can see how, I mean, somebody has to use a computer with visual disability at work. Those same things would be helpful for a visual disability at a library. And that's true for a lot of different things. I had an aunt who had ALS, and I was on the Job Accommodation Network all the time looking for where to find the best resources, and they organize them all sorts of different searchable ways. It's a really great resource.
Thank you, Kelly. I don't see any other questions. I went ahead and put the survey for this program in the chat. We are at 11:59, and I know that there was a lot of information. Please remember that we will be sharing the slides with you afterwards when we've uploaded the recording, along with, I'm going to put the Ask Jan link in there, Kelly's information, the link to Disability Law Colorado. A lot of the resources that they have on their website are applicable to a lot of the work that we do in libraries. And like Kelly said, employment stuff and employment law, in many ways, it is the floor, but when we think about the services that people use the libraries for, may also help us kind of, may help guide the things that we make accessible or available in libraries. Even purchasing stuff might be helpful. We are now at noon. I'm going to stop the recording. Thank you so much for showing up. It is really heartening to know that so many of us in the library, in library land, care about accessibility and want to do the best for all of our patrons and create inclusive environments. Thank you very much. And stopping the recording.